All right, let's jump right into an absolutely game-changing Supreme Court case that fundamentally rewired the relationship between citizens and the police. We are looking at Lalita Kumari v. Government of Uttar Pradesh, citation 2014 to SCC 1. If you've ever wondered what your actual rights are when reporting a serious crime, this explainer is going to give you the constitutional bedrock you need. We're tackling that exact critical moment the criminal justice system is triggered, and whether the police ever have the right to just say, hold on, let's wait. For all you law students and exam prep folks tuning in, we've structured this explainer clearly on screen for you to easily follow along. We'll hit the facts, the court legal issue, the big arguments from both sides, the court's reasoning, those narrow exceptions, and finally, the modern impact with the BNSS 2023. Let's get right into it. Section 1. The facts of the case. To really grasp the legal theory here, we have to look at the human drama that sparked this whole thing. A minor, Lalita Kumari, is kidnapped. Obviously, her frantic father rushes to the local police station. But instead of immediately registering a first information report, or FIR, the police just drag their feet. They decide to do this completely unstructured preliminary inquiry to see if the allegations are actually true first. And because of that massive delay, crucial days are lost, and the suspects literally flee with the child. This wasn't just some administrative red tape, you know? It was a devastating delay that compromised the investigation from minute one. So the desperate father files a writ petition under Article 32, taking this straight to the Supreme Court. He basically argued, look, this police delay is a gross violation of statutory law and a direct threat to personal liberty under Article 21. And honestly, because different high courts all over the country had totally conflicting judgments on whether police could delay an FIR like this, a heavy-hitting 5-judge Constitution bench had to step in and finally settle the law. Moving on to Section 2, the core legal issue. The Constitution bench had to tackle this highly specific burning question under Section 154 of the CRPC, which, by the way, is now mirrored in Section 173 of the BNSS. Are police statutorily bound to register an FIR the absolute second they get information, or do they actually hold the discretionary power to pause and verify the credibility of that info first? Are they basically an automatic recording machine, or do they get to act as the initial gatekeepers of justice? Just to make sure we're totally clear on the terms on your screen, this entire debate revolves strictly around cognizable offenses. We're talking serious, heavy-duty crimes, like murder or kidnapping, that instantly trigger the state's criminal justice system, including the power to arrest without a warrant. For these crimes, the stakes for our civil liberties are incredibly high. The FIR acts as the primary legal safeguard against both unchecked crime and arbitrary police overreach. All right, Section 3, Arguments, Petitioner versus State. So, how did the two sides frame this? Well, the petitioner drew a hard line. Absolutely no discretion. They argued that giving police unregulated wiggle room just breeds corruption, destroys evidence, and shields criminals. You disclose a cognizable offense, they log it. End of story. But the state pushed back hard. They argued that a preliminary inquiry is a totally necessary shield. They claimed this discretion protects innocent citizens from immediate, unjust arrests stemming from malicious, fake, or politically motivated complaints, which, let's be real, definitely happen. Let's look at Section 4, the Supreme Court's legal reasoning. The court's decision essentially boiled down to the literal rule of interpretation applied to one single, incredibly powerful word in the statute: shall. The text says the officer shall enter the information. The bench reasoned, well, shall means shall. It leaves absolutely zero room for administrative hesitation. The legislature specifically chose that word to intentionally strip away police discretion at step 1, precisely to prevent the kind of nightmare delay that let Lalita Kumari's kidnappers escape. And the judges drew a brilliant, razor-sharp distinction here. They pointed out that the statutory requirement simply says the information must disclose a cognizable offense. It never actually says the information has to be credible up front, right? Credibility is the result of an investigation, not some prerequisite you demand before you even open the file. Confusing disclosure with credibility is a dangerous legal error that basically puts the cart before the horse. Look at the chronological flow mapped out on your screen. It is strict. Step 1, information discloses a cognizable offense. Step 2, police mandatorily register the FIR. Step 3, then they investigate to find out if it's actually true. Registration always precedes investigation. The police have absolutely no statutory discretion to pause and evaluate the truthfulness of a complaint. The absolute second a serious crime is disclosed, that procedural machinery has to start turning.
Which brings us to Section 5, the narrow inquiry exceptions.
Now, the court wasn't completely blind to the state's fear of fake complaints. They did carve out some very specific exceptions where a quick preliminary inquiry, which was originally capped at up to 7 days, is allowed. We're talking areas with a high rate of exaggerated claims, matrimonial disputes, commercial frauds, medical negligence, corruption, or cases with some weird, unexplained delay in reporting. In these highly limited buckets, a quick look before leaping into a full investigation makes practical sense to protect the innocent. But here is the absolute vital caveat for all you law students to lock in. Even within these exceptions, the preliminary inquiry is only to see if a cognizable offense is disclosed. It is never, ever a trial to judge if the complaint is actually true. You are literally just looking to see if the facts, as alleged, constitute a serious crime. If that quick inquiry reveals an offense is indeed disclosed, boom, the FIR must be logged immediately, and the standard investigation takes over.
Finally, Section 6, Modern Impact, BNSS 2023.
So, the judicial reasoning of Lalita Kumari didn't just stay trapped in the casebooks. It directly shaped our modern criminal justice architecture. It's been formally codified into the new Bharatiya Nagarik Suraksha Sanhita, the BNSS 2023. Section 173, subsection 3 explicitly allows for preliminary inquiry now, but it puts it in a very tight box, a strict 14-day window. This completely ensures that even when an inquiry is allowed, it can't just be used as an excuse for endless, indefinite delay. And crucially, this 14-day preliminary inquiry under the new code is strictly limited to offenses punishable with 3 years or more, but less than 7 years. This specific statutory bracket completely aligns with the spirit of the Supreme Court's 2014 guidelines. It gives police a structured, legally sound way to carefully assess those middle-tier complaints without throwing the immediate rights of victims reporting the most severe crimes out the window.
So, what is your ultimate takeaway from this explainer? Registering an FIR for a disclosed cognizable offense is an absolute, non-negotiable right, period. Police officers who ignore this mandate and fail to register an FIR are going to face strict disciplinary action. The Supreme Court hammered this constitutional safeguard into place to ensure justice serves citizens from the literal first second a crime is reported.